Am I removable if I'm out of status but married to a U.S. citizen? This is a very frequently asked question and a common scenario that people find themselves in, and I'm here to address it. My name's Regina Cocco, and I'm an attorney. I have a law firm called Cocco Law PLLC. So if you are out of status in the U.S., meaning you entered the U.S. lawfully, but you've since fallen out of status, and you are married to a U.S. citizen, you are still removable. That's because it's not the marriage to a U.S. citizen that permits you to stay in the U.S., but a properly filed adjustment of status application, also known as an I-485 or a green card application. Now, a green card application can only be filed pursuant to a basis to adjust. In this case, it's filed pursuant to an I-130 petition. So if you are not in removal proceedings, those can both be filed with USCIS, the U.S. Citizenship and Immigration Services. The pending adjustment application, or the I-485, is what provides a period of authorized stay. Now, it's important to note that a period of authorized stay is not the same thing as lawful status. Just like you don't obtain lawful status by virtue of marriage to a U.S. citizen, you also don't gain lawful status just by filing the adjustment of status application. What the application gives you is a period of authorized stay. So a period of time when you're allowed to stay in the U.S. while USCIS reviews the application and makes a decision. So if you have not yet filed, you are in fact removable. Now, if you end up in immigration court, you can still file. In that case, you end up filing the I-130 with USCIS and the I-485 in immigration court. That can be a more complicated situation, though. I hope this helps. If you have any comments or suggestions for future topics, please feel free to leave them below. Thank you.